judgment in the matter of Cape Intermediate Holdings Limited versus Dring.
The question is, when and in what circumstances should someone who is not a party to court proceedings be allowed access to the documents which were placed before the court when hearing the case? This is an important question, not least because such non-parties include the media, who are the eyes and ears of the public, enabling public scrutiny of what goes on in our courts. The question arises in rather unusual circumstances. Cape Intermediate Holdings Limited was involved in the manufacture and supply of asbestos and asbestos products. It was sued in the High Court by employers' insurers who had paid out claims made by employees who had contracted mesothelioma in the course of their employment. The insurers claimed a contribution from Cape on the basis that it had been negligent in the production of asbestos insulation boards, that it knew the risks and had provided false and misleading information to employers and others. All of this was denied. The trial generated a huge amount of documentation. There was a core bundle, Bundle C, which included all the documents referred to for the purpose of the trial. There was also another bundle, Bundle D, which contained all the documents which had been disclosed by the parties during the proceedings. The trial took 6 weeks in the High Court. However, after the trial had finished, but before judgment was given, the parties reached a settlement, which was embodied in a consent order. The Asbestos Victims Support Groups Forum UK is an association providing help and support to people who suffer from asbestos-related diseases and their families. It was not a party to the proceedings. Shortly after the case had been settled, it applied to the High Court for access to all the documents which had been used at or disclosed for the purposes of the trial, as well as trial transcripts. It believed that they would provide valuable information about such things as the knowledge of the asbestos industry, of the dangers of asbestos, which might help the parties and the court in other cases. The Queen's Bench Master made orders designed to ensure that all the documents which were still at court remained at court, and that those which had been removed were returned. After a 3-day hearing, she ordered that the forum, now represented by Mr. Dring, should be provided with the trial bundle, including the documents in Bundle C, all witness statements, expert reports, transcripts, and written submissions. Cape appealed to the Court of Appeal, which modified the Master's order, reducing the amount of documentation to be made available, but still requiring very substantial disclosure. Cape now appealed to this court, arguing that the order made by the Court of Appeal was still too wide. There are 2 possible routes whereby a non-party, including the media, may be granted access to the documentation filed in a civil case. The Civil Procedure Rules provide for non-parties to obtain certain documents, quote, from the records of the court, quote, close quote. The forum argues that this applies to any document filed at court, irrespective of whether it has actually been retained in the court's records. The starting point, they argue, should be to allow access to all documents placed before the judge and referred to at trial unless there is a good reason to deny it. The Supreme Court rejects this argument based on the rules. The court records are what the court keeps for its own purposes, not every document which is lodged or held for the time being. On the other hand, the court also rejects the contrary argument, advanced by Cape, that disclosure should be limited to that provided for in the rules, with only a very narrow extension. Current practice in keeping court records cannot determine the scope of the court's power to grant access. All courts and tribunals exercising the judicial power of the state have an inherent common law power to allow access to documents or other information placed before them if this is required by the principle of open justice. It is a fundamental principle of our Constitution that justice is done in public. There are 2 main reasons for this. First, to hold individual courts and judges to account for their decisions. And second, to enable the public to understand how the justice system works and why decisions are taken. In the olden days, when the courts relied much more on oral evidence and argument than they do now, anyone attending the trial might have been able to understand what was going on. Nowadays, the courts rely much more heavily on written arguments and documentation which is not read out in court. It is much more difficult for non-parties to understand what is going on without access to the written material. And it is not always practicable for those with a legitimate interest, including the media, to attend the trial. Hence, the default position is that the public should be allowed access, not only to the parties' submissions and arguments, but also to the documents which have been placed before the court and referred to during the hearing. However, there is no right to such access, save to the extent that it is granted by the rules. An applicant must explain why he seeks it and how granting it will advance the open justice principle. The court will take into account any countervailing principles, such as national security, privacy, or commercial confidentiality. It will also take into account the practicalities and proportionality of granting access, especially when the proceedings are over. Clean copies must be available, and the person seeking access must pay the costs. Hence, in this case, the order already made by the Court of Appeal for access to listed documents will stand, and the case will be returned to the High Court for the judge to decide whether the principles of open justice require that any other documents placed before the court and referred to in the course of the trial should be made available.